Good afternoon and welcome to our webinar on Visit Visa, Making Successful Applications and Challenging Refusals with Adam Pipe from No.8 Chambers. For those of you who haven't joined our webinars before, my name is Sammy. I am the Business Development Assistant of DG Legal. The slides from today's presentation will be sent over tomorrow and a recording of the webinar will be made available. So if we do run over and you need to leave, you will be able to watch the rest at another time. We are in webinar mode, so we can't see or hear any of you, so please use the Q&A function for questions to ask the speaker. So Adam Pipe is a barrister specialising in immigration, asylum and human rights law and is ranked by Chambers and Partners for immigration law in the Midlands. He provides regular updates on the law at training sessions or social media. So over to you, Adam.
Thanks, Sammy. That's fantastic. And it's fantastic to have so many people joining us today for this webinar, Visit Visas, Making Successful Applications and Challenging Refusals. And there's over 1,000 people registered today. So it really shows what an important topic this is. It's great to see so many familiar names on the chat already. Do scroll up to the top of the chat, because what I did there is post a link to a Telegram channel I've set up, which where I post regular immigration law updates. So that's available to anybody. It's a Telegram channel, so you need the Telegram app for that. But do sign up for that. The link is also at the end of my slides, which you will get from DG after the webinar, of course, with the recording that Sammy's indicated that will be available. Before the main feature, there's always the trailers in the cinema. So just two quick trailers for you. On the 20th of April, Amy Higgins and I will be doing a webinar on the changes to legal aid. So check that out. Amy's the main person delivering that. I'm just making a bit of a guest appearance, but that should be a fantastic session. And then in July, I'm going to do my next free webinar, which will be on children and entry clearance. So if you've been stumped on issues like sole responsibility and serious and compelling, sign up now for that webinar. I've already seen some questions in the chat, in fact, about how do I raise human rights in a visit visa application. So we'll look at all that things as we go along today. There's so much in my slides. We may not get to questions. I'll see what I can do. But hopefully these slides will be helpful for you to paste into your representations, into your pre-action letters, and maybe into judicial review grounds. So what's the problem? Well, anybody who's got any experience with visit visa applications over recent years will have been faced with repeated poor quality refusals. It feels like you're stuck in Groundhog Day, where whatever documents you submit to the entry clearance officer, you get the same rubbish refusal back. Now, in the good old days, we had a right of appeal in family visit cases. Then that was reduced, where there was only an appeal on human rights grounds. And now, prima facie, there is no right of appeal in a visit visa case. Although, if it's a human rights application and the refusal is a refusal of a human rights application, and we'll come to that later on, you may have a right of appeal, but there are huge difficulties in visit cases with human rights appeals. Unfortunately, there is no right of administrative review. So the only option is to go down the pre-action protocol route often, and then make an application for judicial review. But as I've said there in the fourth bullet point, judicial review is a limited remedy. I read this quote on free movement recently, which encapsulates the difficulties with visit visas. It says this: the lack of an affordable and effective mechanism for challenging visit visa refusals has led to a marked decrease in the quality of decision-making. The reasons provided for refusal are often spurious, and important documents are often simply ignored. There is no oversight or accountability. Decision makers can essentially do what they want, safe in the knowledge that few have the money or the wherewithal to challenge their decision. With no external quality control, decision makers do not learn from their mistakes until a more expansive right of appeal is reintroduced the problem is likely to persist. And I'm sure everybody watching will be saying amen to that, because that encapsulates the difficulties we have. So what about the immigration rules? Well, the primary immigration rules in relation to visit visas are set out in Appendix V. If you're a visa national, you will need to apply for entry clearance as a visitor. Non-visa nationals can normally seek entry on arrival to the United Kingdom. And Appendix V sets out the 4 main types of visitor that there are. There's a standard visitor. Now, normally an application you make for a 6-month visa. You can apply for multi-entry visit visas for 2, 5, or 10 years, although you can't exceed 6 months in any one stay. There's the marriage or civil partnership visitor. There's the paid permitted engagement visitor. There's the transit visitor, and look at Appendix Visitor Transit Without Visa Scheme. Also, visitors can't work unless they're allowed under the permitted activities. And there's a separate appendix, Appendix Visitor Permitted Activities. Now, I'm not going to spend a lot of time looking at the rules themselves today, specifically in terms of things like permitted activities. In fact, there is a good course if you're signed up to free movement and do the CPD courses on there. There's a good 2 CPD point course on visit visas that goes through the mechanics of the rules and addresses things like permitted activities. I do want to flag up V 3.1. So Appendix V has suitability requirements, and it cross-refers to the general grounds of refusal in Part 9. So the general grounds of refusal in Part 9 apply. So Appendix V is a bit different for something like Appendix FM, which has its own built-in suitability rules. Now, it's worth paying close attention to Part 9, because if your client perhaps fails to disclose something in their immigration history, that's where they're going to get bitten under Part 9 and perhaps get a re-entry ban. And in fact, at 9.4.4, there is a separate criminality threshold in relation to visitors. So visitors have a stricter criminality requirement under the general grounds of refusal in Part 9. So make sure you're familiar with Part 9, because those suitability requirements will apply. So what's the key issue, the issue that you're going to see in most refusals, and the thing that we find ourselves banging our heads against a wall about? It's the genuine visitor requirement. Now, this is set out in V 4.2 of the immigration rules in Appendix V. So let's look at the key requirements, and often you will be familiar with refusals under subparagraph A and subparagraph C. So A is that they'll leave at the end of the visit, and C is that they are genuinely seeking entry or stay for a purpose that is permitted under the visitor route. So we don't think you're genuinely seeking to enter as a visitor, they'll say in the refusal. The other rules are important. So look at B. That's about somebody spending too much time in the United Kingdom through frequent or successive visits and effectively making the UK their home. D is about the prohibited activities, and there are specific prohibited activities in 4.4 to 4.6. And then E deals with funding. So they must have sufficient funds to cover all reasonable costs in relation to their visit without working or accessing public funds, including the cost of the return or onward journey, any costs relating to their dependents, and the costs of plans activities such as private medical treatment. Now, those funds can be met by a sponsor. So V 4.3 says this: in assessing whether an applicant has sufficient funds under Appendix V 4.2.E, the applicant's travel, maintenance, and accommodation may be provided by a third party only if that third party has a genuine professional or personal relationship with the applicant. So you'll need to show that. They themselves will not be in breach of immigration laws at the time of the decision or the applicant's entry to the UK as a visitor, so they don't need to be settled. And C, can and will provide support to the applicant for the intended duration of the applicant's stay as a visitor. But in the majority of refusals that I see, it's not the sponsor's circumstances that are the issue. I just looked because last week they updated the Home Office policy on visa waiting times for applications outside of the UK, and the current times given are 3 weeks. Obviously, you potentially can apply under the priority service for a quicker decision. So let's start to talk about some tactical considerations in trying to get a successful decision. And the first thing I want to say is representations are essential. Back in the day, I think everybody used to thought, well, visit visa applications, money for old rope, dead easy, just fill in the form, stick in a few documents, away we go. But as we all know now, visit visa applications are deceptively difficult and very difficult to succeed in often. So I think drafting representations are essential. So often when I get sent a decision, and people say, Adam, are there merits to challenge this decision? There are not proper representations that were submitted with the application. Now, I appreciate that might be difficult because if you're a representative, a client may be reluctant to want to pay for you to do detailed representations, but I think they're essential, especially if our main route of challenge is going to be doing a PAP letter and then a judicial review. The representations lay the foundation for a subsequent challenge. And if that foundation is not there, even if the decision is a rubbish decision from an ECO, imagine being at a judicial review hearing and the judge saying, okay, Mr. Pipe, I accept the ECO doesn't engage with anything, but you show me where in the material submitted was that material. If you've got representations that clearly set that out, you're at a strong advantage. Now, you'll be able to use these slides as the backbone for your representation. So if you work in a firm or you run a practice, you may want to take some of these extracts and put them into your precedent representations letter. Don't just press print for every case and just have standard blurb. Address the individual case. So set out the rules and how they're met by your client. This needs underlining and highlighting. Deal with previous refusals and immigration history. A failure to declare previous refusals, previous immigration history is going to come back to bite you and leave your client with a re-entry ban. Cross-refer to the evidence and the statement. So where there's evidence of ties to the home country, set that out. Where there's evidence of income, etc., cross-refer to that. Set out the relevant policy and case law, because often entry clearance officers don't properly engage with their own policy and don't follow the approach set out in the case law. And we're going to come to that case law as we go through the webinar today. If it is a rare case you are arguing Article 8 and you're thinking, well, if this is refused, this is one where I want to take it to appeal, make sure you properly argue Article 8. Set out the relevant guidance, and we're going to come to a Home Office specific policy. I didn't know this. The Home Office have a specific policy for human rights in visit visa cases, and we're going to go through that today. So representations are essential. Good statements are essential. I often see a statutory declaration from the sponsor, but I often don't see proper statements from the applicant. I think that's essential. Setting out why they want to visit, their ties to their home country and their reasons for returning. Set out a statement from the sponsor and make sure the sponsor addresses their own situation, but also the applicant situation at the end of the webinar. So don't log off early today. We're going to come to a recent Scottish case, and I talked about it in my last webinar on the key cases. You can still watch the recording of that, of a case where a Scottish JR and they quash the decision for a failure to consider the statement of the sponsor. If there are family members back in the home country or other family members here in the UK and it's a family visit, or relevant people, provide statements or letters from them as well. Another quote from Free Movement, which emphasizes the third point. So if representations are essential, if good statements are essential, thirdly, documentary evidence is essential. This really encapsulates things. The way to approach preparing an application is to accept that the ECO will assume you're lying about anything that you cannot prove with documents produced by a verifiable independent organization or company. And I think that really encapsulates it. You need documentary evidence to back up your claims. Fourthly, then, check, check, and check again. Check the form carefully. I know a lot of visit visa cases are often prepared by visa agents abroad, and we often see a lot of mistakes or non-disclosure in the forms. So check the form carefully. Make sure all the questions are answered and there's no gaps in the form. And then most importantly, answer every question carefully and truthfully, and especially the immigration history section. Make sure you press your client about previous refusals, especially if there's been perhaps a previous refusal on deception grounds, or they've been previously removed or had a removal notice in the United Kingdom. So check the questions, check they've been properly answered, especially the immigration history section. And again, assume that the application will be considered by a person who will assume that everyone is lying unless you can prove otherwise with independent and verifiable evidence. So there's some practical tips. Let's look at some Home Office policy. I think this Home Office policy is great in terms of advising your client. So stuff to set out in your client care letter saying, right, you want to apply for a visit visa. Here are the documents I need. Stuff to put in your representations about how the ECO should consider the case. And also things then when you're challenging the decision, things to put in your pre-action letter or your JR grounds, or in the rare occasion of a human rights appeal, maybe in your appeal skeleton argument. So there's, I think, 3 policies I want to look at. The first one is called Visiting the UK Guide to Supporting Documents, and that was updated on the 18th of January 2021. So you've got to show you're a genuine visitor. You can do this by providing evidence that you're coming to do a permitted activity. You leave, you're able to support yourself and any dependents, and you're able to pay for your return journey and any other costs. Documents, apart from passports, can be originals, scans, or photocopies, but don't forget to get translated documents. I still see a lot of untranslated, say, land documents to show the client has land back home. Make sure the relevant documents are translated and there's a certified translation. So demonstrating your personal circumstances, it says if you're intending to visit the UK, you'll need to show that you are a genuine visitor who is coming to the UK to undertake a permitted activity, that you will leave and you have got sufficient funds. You need to provide information about your circumstances in your home country and details of the activity you'll be doing in the UK. So here's a list. It's not exhaustive in the guidance, but again, it's helpful. And it's helpful. You can refer your client to it and make sure you cover it all. The first bullet point relates to documents they suggest you get if you're coming for activities related to your employment or study outside the UK. So I'm not going to read that one and the sub bullet points to that. But the second bullet point, previous travel documents or passports which show your previous travel. Your travel history, as we're going to see, is relevant, and it's something that could show you are a genuine visitor. So make sure those documents are submitted. Confirmation of legal residence. So if you're living in a country where you're not a resident of, perhaps proof that you've got a right to reside there. Financial documents showing that you have sufficient funds available. That's a key. These must clearly show that you have access to the funds, such as bank statements, building society books, proof of earnings, such as a letter from an employer confirming employment details. So with bank statements, make sure if there's large deposits going in there, you've explained what they are, because we'll often see refusals saying, you've said you earn X number of thousand rupees a year, but we've seen deposits going in there that far exceed your income. Now, that may be because you also have land on rent. Well, make sure the information is set out in the statements and cross-referred in relation to the bank statements. Or if your client gets paid cash, they're in a society where they use the cash for their personal expenses and only deposit sporadically into the bank, then that's worth saying. If the sponsor sends money to them and there's regular remittances, make sure that's explained. In terms of proof of earnings, obviously, if they've got a job, make sure that's referenced. But if there's other income, like houses that are on rent, land that is on rent, etc., other forms of income, make sure you show those, because if there's unexplained income, the entry clearance officer will refuse. If you've got a sponsor, make sure they can provide evidence showing what support is being provided and whether it extends to any dependents, how the support is being provided, the relationship between you and the sponsor, and obviously that the person is legally in the United Kingdom. So that's the first piece of guidance. That's the guidance on documents. Then there's the visit caseworker guidance, a large document well worth referring to in your representations. So I put a few sections in. This is the section assessing an applicant's genuine intentions to visit. You've got to be satisfied that they meet all of the requirements of V4.2 to V4.6. A visitor can enter or extend their stay to do different permitted activities, but they should be expected to have a main reason or reason for visiting. So you may be doing more than one thing, because you may be visiting family and traveling, but you've got to have a main reason, and your reason for coming may change. What are the factors that will help an ECO assess whether somebody's a genuine visitor? Now, I often use these in judicial review grounds or suggest that solicitors put these in pre-action letters, because often there are things that are not considered by ECOs. They just say, well, you've got unexplained bank deposits, therefore I don't think you're a genuine visitor, and haven't done a proper holistic assessment of the applicant's intentions. So what about their previous immigration history, including visits to the UK and other countries? That might point in favour of them being a genuine visitor. Duration of previous visits. Did they stay longer than they originally stated? So I'm coming to the UK for 2 weeks. They get 6 months visit visa and they stay much longer. Now, that in and of itself shouldn't automatically lead to refusal, but it's something worth addressing, because I'm sure a number of us on the webinar today have seen those type of refusals. Their financial circumstances, as well as their family, social and economic background, their personal and economic ties to their country of residence. And that's important. They may say, well, look, you're a single young man living in Bangladesh, your parents are here, you're unemployed, you've got no ties, no reason to go back. The cumulative period they've spent in the UK, especially their pattern of travel over the last 12 months, and whether in fact that amounts to de facto residence. Whether on the balance of probabilities, the information and the reasons for the visit or for extending their stay provided by the applicant are credible and correspond to the personal, family, social and economic background. Often we see refusals that say the amount you're going to spend on this visit is not consistent with your own financial circumstances and far outweighs that, so worth addressing. As I said earlier, travel history is relevant. So a pattern of previous compliance with UK immigration law may indicate you're genuine. as does visits to other countries. And the Home Office guidance especially highlights Western countries and European, notice the reference to Schengen countries or Switzerland. Obviously, the converse applies. If you've got a bad immigration history, that might count against you. Again, the one thing to say is make sure you've set out all your history so there's no material non-disclosure. Now, one of the rules was, well, you can refuse somebody as not genuine if they're making the UK their de facto place of living and they keep coming here. So what factors should we look at? Well, the stated purpose of the visit and the intended length of stay, the number of visits over the last 12 months and the time of each occasion and the time lapse between visits, the purpose of return trips to the home country. Is still their home country their ordinary place of residence? Or, look at the next bullet point, have they registered with a GP or a school in the UK, making it look like actually the UK is now becoming their main place of residence? Their history of previous applications. But remember, there is no rule that you can only spend 6 months in any 12-month period. Obviously, an individual visit must not go over 6 months unless you get a rare occasion, you get an extension. But there's no rule that says you can't spend more than 6 months in 12 months, but they will look at all these factors in seeing if you're effectively making the UK your main home. What are the reasons given in the guidance for doubting whether somebody is a genuine visitor? Now, you're going to want to say these are not present in your case and say, well, I am genuine. So the applicant has few or no family or economic ties to their country of residence and has several family members in the UK. But as we'll see from the case law, that's not really a reason in and of itself for doubting that somebody is genuine. Has there been an attempt to deceive in a previous application? Well, you're probably going to be refused under Part 9. Are there discrepancies between the statements made by the applicant and the statements made by the sponsor? Now, that's something to watch. Perhaps if you prepare the sponsor's documents in the UK and a visa agent abroad prepares the application and there are conflicts between the two. Has it not been possible to verify information? Is the information provided not credible? Or perhaps on arrival, are there things in the baggage of the individual that makes you think they're going to stay in the United Kingdom? I just wanted to point this out about change in circumstances. There's a power to cancel a visit visa because of a change in circumstances, but this guidance does say that somebody can change. It is also possible, look at the final paragraph, that a visitor having indicated on a visa application that they intended to undertake a particular permitted activity changes their main purpose for visiting before or on arrival at the border. For instance, they propose to take part in a sporting event that is subsequently cancelled and they come here for a holiday instead. Or a classic one I see is I applied to come for a wedding. By the time we get the decision, the wedding's happened, but we still, or a birth of a child, we still want to come for a family visit in those circumstances. Now, here is this piece of guidance that's specific for human rights claims in visit applications. So it's version 1.0. It's a 2015 piece of guidance, and it still is live on the Home Office site. So this is their approach where human rights claims are raised in visit applications. So if you're thinking this is one of the rare cases I want to rely on human rights, this is how they're going to approach it, and this is worth citing in your application. So there are 4 steps in blue. Does the application say that it's a human rights claim? Or 2, does the application amount to an implied human rights claim if it does not say that it's a human rights claim? Now, so you can have an implicit human rights claim, but if you want to rely on human rights, don't rely on the ECO deciding it's an implicit human rights claim. Make it explicit and put detailed representations. Are there matters, step 3, are the matters raised capable of engaging human rights? If they think not, then you're going to be refused with no right of appeal. They won't engage with the human rights. Does the human rights claim have any prospects of success? If no, then refuse the claim with a right of appeal. So if human rights are engaged, but they don't think you're going to win, they still should give you a right of appeal. If they think you should be granted on human rights grounds, they should refer the case to the referred cases unit. I've put some of the guidance here. Step 3, other matters raised capable of engaging human rights. Look at this. The starting point for considering a visit application is that a visit does not generally engage human rights. And they say effectively the only relationships that may engage Article 8 are a spouse or other life partner, a parent where the applicant is a minor child, or a minor child. Now, there may be exceptional circumstances outside of this, but prima facie, those are the relationships where we're going to see potentially Article 8 engage, and that's supported by the case of Mustafa. But look at the final part of this slide. Even where the claim is based on one of these relationships, the starting point is that Article 8 is not generally engaged where a visit visa is refused. They do give the positive guidance of a positive duty to respect family life. And they point the circumstances of where a sponsor or the person they want to visit in the UK can't travel to the home country. I always give the example, say where there's somebody in the UK who's disabled and can't travel to visit close family. So that's the example similar to what they give. If a minor child of separated parents wishes to visit a parent living in the UK and that parent is unwell so that they cannot travel, then refusal of the visit visa could amount to a failure to comply with the positive duty to respect family life. And the case there is EWCA versus SB. That the non-anonymized version of that case, it's called Shamin Box, and I'm going to refer you to that in a bit. Circumstances that may displace the presumption that a visit application does not engage Article 8 are rare and will be exceptional. You can only decide whether exceptional circumstances exist by looking at the application as a whole. So you're really going to need to provide significant evidence if you're going to get a successful appeal on Article 8 grounds. And then they'll consider, does the human rights claim have a reasonable prospect of success? If they think there's a human rights claim and human rights will be engaged, but either there'll not be an interference or the interference will be proportionate, they should, their guidance say, give you a right of appeal. If they think you should be granted leave, they should refer it to the referred cases unit. So do cite this guidance if you're relying on human rights. Now, a shout out, I'm doing a shout out to Free Movement and their visit visa course. I wanted to give a shout out to McDonald's Immigration Law and Practice. A lot of people, I think, since things are online, don't tend to look at immigration law textbooks anymore, but there's some really helpful stuff in McDonald's. So a shout out to them. I would encourage you to sign up to McDonald's, either digital version or even a paper version, because there's some really helpful stuff. And what I've done, I've put in the slides the footnotes, because the footnotes give you some really helpful old case law. So look in the middle of paragraph 8.29. The exact length of stay may be difficult to ascertain, and it is quite wrong for the immigration officer to refuse leave merely because he or she thinks the passenger may seek an extension of stay. And that footnote 3, and it gives you the case there. So this is something you might want to rely upon and use these cited cases in the footnotes in your representations or in your pre-action protocol letter. So look at 8.30 of McDonald's. Other factors which may be taken into account in deciding whether a person genuinely seeks entry as a visitor include the family's immigration history, so that's worth addressing, the length and purpose of the visit, and their means and position in their own country, previous immigration history and evidence of a pattern of family migration, both here and abroad, may be taken into account. And again, the case law is there. 8.31, in considering an applicant's intentions, and this is really important, a distinction has to be drawn between a wish and an intention. A wish is not an intention unless there is some reasonable prospect of it being fulfilled. The previous expression of a wish to settle or study in the UK is not necessarily prejudicial to a subsequent application for a visit. Footnote 2. Otherwise, someone who discloses an earlier wish to settle could never subsequently qualify as a bona fide visitor, footnote 3. So helpful there where somebody's previously applied perhaps as a student or to settle, been refused and now wants to visit. You can flag that up, that the fact they've made those previous applications does not necessarily mean they don't have an intention to return to their home country and they actually intend to stay in the United Kingdom. And then finally, 8.32, it is always the applicant's intentions which count rather than those of the sponsoring relative or friend in this country. It is the attention on the present visit that's critical. So it's on the intention of this visit that's critical, obviously, but if there's previous deception, you're going to be refused under the suitability. And I really find this last sentence helpful, and I've used this case before. The fact that the sponsor is likely to ensure the applicant's departure is a relevant factor to be taken into account since it tends to show an intention to depart. That's the entry clearance officer New Delhi and Kumar from 1978. So we're dusting some old stuff off today. So when you're doing your statement from the sponsor, make sure the sponsor says, I will make sure he or she departs at their end of the visit. And when you're doing your reps, you can say, please note the sponsor confirms that they will ensure that the applicant returns. And this is a relevant factor. See entry clearance officer New Delhi and Kumar. What are options then for challenging decisions? Well, fresh application is the first thing. Look, if somebody rocks up at your door at 2:30 this afternoon when we finish this webinar with a visit visa refusal, don't think, oh, I just listened to Adam. I tell you what, I'll email him. Adam, let's JR this one. But actually, the application didn't contain all the key material. It didn't lay a proper foundation. What we need to do, particularly because often our only way of challenging is a PAP letter or a judicial review, is lay a good foundation. And that's one of the key takeaways from the webinar today. So, and it's often a cheap way forward is the fresh application. So make sure you lay the groundwork because it's a better chance of getting it granted or a better chance of challenging. Secondly, a pre-action letter. That's a precursor to a judicial review and must be done in advance of a judicial review. But it's worth often sending a pre-action letter. Remember, if you're an OISC advisor, you can only go as far as the pre-action stage and unless you're authorized to do judicial review, and then you have to refer to a solicitor or whatever. But a pre-action letter sometimes in and of itself gets things sorted and will lead to a reconsideration. Then there's judicial review, and we're going to come to that in a moment. Or there may be those rare occurrences where you can appeal. But we're going to see that is limited and has problems. So we'll come to that in a moment. Let's look at the limitations of judicial review as a remedy, because I think one thing we need to do is manage client expectations. Because often the remedy in a judicial review is the quashing of a decision and not the granting of a visa. Back in the old days when we won our visit visa appeals, somebody would get their visit visa. But what happens when we're successful in a JR is they get a reconsideration. And mandatory orders are very, very rare. Look at the case from Mr. Justice McCluskey when he was president, Sultana. The main remedy in JR, point 1 is a quashing order. Look at point 2, the remedy of a mandatory order is rarely granted. It is appropriate only in cases where it is clear to the court that the respondent is legally obliged to take a certain course of action, normally involving the conferral of some benefit or advantage on the challenging party with no choice or discretion. I can't really see a visit visa case where you're going to get a mandatory order. Unless perhaps they settle a previous case by saying within 2 weeks, we're going to grant the visa and then don't grant the visa. Then if they promise to do that, maybe you get a mandatory order. But otherwise, if it's just the quashing of a decision, the court will not go further and issue a mandatory order. And reconsiderations may well lead to another refusal and another and another. I know there's a solicitor on the webinar today because I've seen his name already, where I think we're on our 3rd or 4th time around the block. It's so frustrating. We do a JR, they consent, they pay our costs, they refuse it again on things they never raised originally, and it's just becoming abusive. And I think then we have to think about complaints, getting the MP involved. and in a JR, threatening perhaps indemnity costs. And that's the other limitation of JR, that the cost risk to your client. Obviously, if permission is refused and the case ends at that stage, you'll be ordered to pay the costs on the acknowledgement of service. That usually is, say, £500 to £1,000. That's rough already. If we lose at a full hearing, the costs of a full JR are in the thousands of pounds, say £5,000 to £10,000. Now, those are figures off the top of my head and only examples. But remember, if you've got outstanding litigation costs, you can't make a new immigration application. See Part 9 of the immigration rules. Here's the extracts from the pre-action protocol in the civil procedure rules. There is a pro forma for the Home Office pre-action protocol. If you're going to write it in letter form, make sure you set out a summary of the facts and the legal basis for the claim, and you need to give the Home Office 14 days in order to respond. Here's the link so you can use it to the template. So the template would be available in Visit Visa Challenges, and that's a much simpler way of getting a pre-action protocol letter out. So use that template through the link I put on this slide. What are the difficulties with appealing then? The Visit Visa application must itself constitute a human rights claim, and the decision must constitute a refusal of that human rights claim. So if you make a human rights claim, but they don't engage with the refusal, that's not a refusal of a human rights claim. See the domestic violence case of MY Pakistan. If you are lodging an appeal, say on the My HMCTS system, in a Visit Visa case, I would set out somewhere, or it'll have to be in your appeal skeleton argument, why you say that it is a refusal of a human rights claim, and it is a refusal of that human rights claim, and therefore you have a right of appeal. Because the last thing you want is to say to your punter, right, let's appeal. You go through the process, you get before a judge, some smug Home Office presenting officer rocks up on the day and says, haha, that's not a refusal of a human rights claim. The judge agrees, says there's no valid appeal before me, and the JR deadline has passed. Nobody's happy at that point. Just some case law for you, and I'm conscious of time. So in terms of Article 8, Mustafa was in that interim period. So where we first had rights of appeal, full rights of appeal in family visit cases. Then there was the interim period where you could appeal on human rights grounds only. Then appeals were removed, but subject, obviously, where you can say it's a refusal of a human rights claim. And this was a wife visiting a husband. The Home Office argued that Article 8 would not be interfered with. The President and Upper Tribunal Judge Perkins relied on sham in box and said, undoubtedly, the paradigm Article 8 entry clearance case concerns applicants seeking to join close family members for the purposes of settlement. However, it cannot be excluded that where one party to a marriage is entitled to be in the United Kingdom, a qualified obligation to facilitate spousal unification for the limited purpose of a short visit and sojourn may arise and does arise here. So in this case, they found Article 8 was engaged and the decision interfered with that Article 8 rights, although they did say it's going to be very limited to close family relatives. Now, there was some slight rowing back. So we have Adeji, Upper Tribunal Judge Southern, and he said, look, the first question to address is Article 8 engaged? The key issue is not are the rules met, it's whether Article 8 is engaged. Only after that, we look at whether the rules are met. And it's only going to be a rare case that Article 8 are engaged in a visit visa application. There was Core, which is a more helpful decision from Dr. Story. And he does say, again, where Article 8 is engaged, the starting point then is to consider meeting the rules. So if Article 8 is engaged, it's a significant factor that you would meet all the visitor rules. Although in the last Article 8 visit case I did, the judge said, all right, I accept Article 8's engaged, but then found we wouldn't meet the visitor rules. So again, we failed in that appeal. Abbasi is a helpful case where Mr. Justice McCluskey found that Article 8 was engaged in terms of Article 8 family life in order to come and mourn after the death in the UK of a family member and visit the grave. And he found that Article 8 had been approached in an impermissibly narrow way by the first tier tribunal and accepted Article 8 was engaged in that case. But of course, it's a fact-sensitive context. Now, these were all around 2015 because the full appeal right had gone and the tribunal had been allowing some visit visas on Article 8 grounds. So what happened in 3 cases, and probably more than that, but 3 significant cases, the Secretary of State appealed all the way up to the Court of Appeal and won in all 3 of those cases. The first one was the case of Kopoi. In that case, it was adult family relationships. I think it was like an uncle and a niece. And they found that the first tier and the upper tribunal were wrong to hold that there was family life. Remember, with his adult relationships, there needs to be that additional dependency, cugathus. So they found the upper tribunal and the first tier tribunal were wrong. They set aside the decision. And they said there's no positive obligation to promote family life if family life is not engaged in the first place, look at paragraph 23. And again, they rely on Mustafa, and whilst Mustafa was a helpful case, obviously it very much limits the type of relatives that Article 8 will be engaged with in a visit refusal. The other thing that was said, paragraph 30, is the shortness of the visit. So even if family life is engaged, the Court of Appeal held here, well, it was only a short visit, so I don't think that actually the refusal thereof represents an interference with that family life. And unfortunately, at paragraph 32, they do set out the limits of judicial review, because obviously in a judicial review, we have to show that the decision is Wensbury unreasonable. So unreasonable, a reasonable decision maker wouldn't have made it. So again, they highlight the limits of judicial review. Then there was the case of Onarua. In that case, again, it was found it was a visit to brother, and again they overturned that decision, found that there was no family or private life for the purposes of Article 8. So family life, again, not engaged. In Abbas, what was argued there? Well, it was adult family relationships. So they said, all right, no family life, but there's private life to visit your adult family members. And what about the positive obligation to promote your private life? And in Abbas, the Court of Appeal found there was no positive obligation in entry clearance cases in terms of private life. So 3 negative cases from the Court of Appeal emphasizing the difficulties of successfully appealing on human rights grounds. I want to end on a more positive note. So we've got 10 minutes left. I'm just going to give you some quick, helpful case law. This is the stuff to flag up, to rely upon in your representations. And then we're going to end just by touching on allegations of deception or misrepresentations. I don't think I'll get to Q&A looking at the time. I apologize for that. What about economic incentive to return? Entry clearance officers often return saying there's no economic incentive to return. Ogunkola is a helpful case in that. Look in the middle of this paragraph. As the tribunal said in Blair, that's another case, if lack of economic incentive to return to the country of origin was sufficient to found a refusal of a visit application, then no person living overseas whose standard of living there was lower than that prevailing in the United Kingdom could ever come on holiday here or visit relations settled in this country. That is not the law. What about a pattern of legal family migration? Gurgur is the case. It says here, of course, no one can be sure of another person's intentions. However, if a pattern of legal migration by members of a family excluded per se other families from visiting them, it is difficult to see why the visit visa system was put in place at all. Several matters, most notably finance, which counted against the appellant in the determination and the decision have now been clarified in her favour. Undue weight appears to be given by both the respondent and the adjudicator to the migration history of the younger members of the family, without recognizing also that there is no evidence that they've been in breach of our immigration rules and that 2 of her children remain in Turkey, so good reasons to go back. So helpful case. What about how a visitor will spend their time? ECO, ACRA, and W. The point is made in this case that family visitors are in a different position, say from a general tourist. A general tourist might set out where you want to go, but the whole point of a family visitor is to visit their family. So look at paragraph 18. In this regard, the family visitor is in a slightly different position from persons whose visit intentions are less specific. In regard to the latter, what account they give of how they intend to spend their time is directly relevant to consideration of the underlying purpose of the proposed visit. For the family visitor, however, all that is strictly required is to have the purpose of a family visit. And they quote from the helpful case of Ashraf. So have a look at that, some helpful stuff there. What about ties to your home country? Another decision by Tribunal Judge Perkins, the case of A. The adjudicator found in this case, I am unable, however, to find fault with the reasoning that the appellant as a young single man has not demonstrated sufficiently strong ties with Nigeria, something we still see in refusals. The adjudicator did not have to find fault with that reasoning. It is not a requirement of the rules that the appellant has strong ties with Nigeria. Certainly is a fact in the case that can illuminate other evidence, but it is irrelevant that the entry clearance officer thought that this is an important point unless he persuades the adjudicator that it is by relevant argument. What the adjudicator should have been doing was asking himself if the evidence persuaded him that the appellant satisfied the requirements of the rules, and strong ties is not a requirement of the rules. You've got to distinguish between incentive and intention. Just because you might not have an economic incentive to return doesn't mean you haven't got a genuine intention. For those of us who've been around a long time, you may have remembered doing cases under the old sectors-based scheme back in the day. Well, here's an extract from the case of AA, which was a sectors-based scheme, not a visit case. Look at this. The fact that an applicant has no apparent economic reason to return to his home country does not mean that he has no intention of returning to his own country at the end of his employment. Opong looks at the length of stay by visitors and emphasizes that there's no general rule saying, no, you can't spend more than 6 months in 12 months. Obviously, the more you stay, they're going to scrutinize it, but there's no general requirement. And so they say, we agree with Mr. Turner, if in fact a person who applies for entry clearance as a general visitor meets the requirements for admission as a general visitor, then that person is a general visitor and is entitled to entry clearance. So helpful stuff there. Swaminadin is helpful in general considerations in terms of time that needs to be elapsed, the relevance of periods of time before visits, links to home country and the materiality of that worth going through. And in this case, a judge, a notorious judge who used to sit in Nottingham, found that overall the visits were probably used, we were probably to use such visits in the future as a preliminary to settlement. So he thought that she was going to settle and there was no justification for that finding just because of the frequency of the visit. So have a look at this case, very helpful. This is the Scottish case I referred you to, Ghulam Sagra. This was the one where they doubted the circumstances in Pakistan, but they didn't consider the statutory declaration, the statement from the sponsor, and that led to the quashing, or it's a Scottish case, so the reduction of the decision. And I've set out here the key paragraphs which you can put in your representations. A final case is the one on fairness, Diaquino. This was a Brazilian national, so a non-visa national, interviewed on arrival, interviewed about his earnings from his barber shop in Brazil. He offered to show his bank statements online if he had access to the internet. The immigration officer didn't give him an opportunity to do that. And the administrative court in this case found that that was unfair. The decision wasn't quashed, though, because the evidence in his bank, when it was disclosed, didn't show those earnings. So make sure, again, your evidence backs up your assertions. Just finally then, in the last 2 minutes of the webinar, false representations and re-entry bans. So there are those two provisions, 9.71 and 9.72, 9.71 being discretionary, 9.72 being mandatory, where there's been in 9.71 false representations or relevant facts not disclosed. 9.72 is where on the balance of probabilities, the entry clearance officer can show deception has been used, and that will lead 9.81 to a re-entry ban. And we know that potentially that could be a 10-year for deception re-entry ban. Let's give you some key case law. DK and RK, the burden of proving fraud is on the Secretary of State, and the balance is, the standard of proof is the balance of probabilities. It's a TOEIC case, but it applies to Part 9. Where the Secretary of State argues that there's been false representations or deception, that requires dishonesty. That's AA Nigeria, and that was confirmed in an upper tribunal case on paper appeals called Shen. And I've just gone back finally to an old case on proof of forgery, where the Secretary of State makes an allegation, or the ECO makes an allegation of forgery. That needs to be proved by evidence by the person making it. A bare allegation of forgery or an assertion by an entry clearance officer that he believed the document to be forged can, in these circumstances, carry no weight. So where we've got these type of allegations, obviously this is how you're going to attack them in your pre-action letter or your judicial review. So I hope that's been helpful to you. I'm sorry that we've gone slightly to time today and we haven't had time to deal with questions. Maybe one of the ideas for a future DG webinar would be to do a full hour of Q&A where we can follow these up together. I'll have a think about that and see if we can put that in. Do sign up for those free immigration updates on the Telegram channel, or I often post on LinkedIn and Twitter. But remember to get the evidence together, do your representations, get your evidence, check the forms, think about your remedies, and really lay that foundation. So thank you so much for joining me today. I'll just hand back to Sammy, who will help tell you about feedback and how you get the slides and the recording. Thanks, Sammy.
Well, I just wanted to say thank you again for presenting, and that is definitely something that we can consider. So thank you to everyone for joining us. As a reminder, the slides and a recording of the webinar will be sent over by email tomorrow. This afternoon, you should receive an email asking to rate us out of 5 stars. If you've enjoyed today, please do leave us some feedback and any suggestions you have for future topics. So our series of webinars continues on the 30th of March, where Paul Whiteman will be presenting a webinar on the Legal Ombudsman rules changes. So thank you for watching and good afternoon.
Thanks, everyone.